People who are saying this have actually taken the time to read the Constitution of our country.
The president has today backed the court's decision, paving the way for the deputy speaker to vote while presiding. But the minority has fired back, insisting the court was simply doing his bidding.
Essentially, as you listen to the president, when the Supreme Court is doing his bidding, what do you expect him to come out with? Just marks of an oversimplification and understanding of the matter.
We also hear from the majority leadership as they warn their minority colleagues against threatening the country's democracy.
This is Top Story with Evans Mensah.
And Top Story is always brought to you by Vodafone. It's also brought to you by Prime Insurance. Now, President Akufo-Addo is tonight taking on critics of the Supreme Court, including the NDC minority in Parliament, insisting they had refused to read the Constitution. The Supreme Court yesterday declared that a deputy speaker can vote while presiding. In its landmark judgment yesterday, it ruled that the deputy speaker can additionally be counted when a quorum is to be formed for a decision making. The court also set aside a part of Parliament's standing orders that deprived the deputy speaker of a vote while presiding. The NDC minority in Parliament had accused the court of unjustifiable interference in the work of the House. Well, today we are hearing from the president himself, President Akufo-Addo. He first explains why he had adopted a position in the past never to comment on constitutional matters.
Let me begin, first of all, by saying that as a rule, I've made it a point since I became president, as much as possible, not to comment on constitutional issues in the country. I think people who are students of our constitutional law, our constitutional jurisprudence, are very much aware of the role that I played when I was a barrister in helping define some of its basic principles of interpretation. And I think that now I've become president, if every time there's a constitutional matter I'm heard to pronounce on it, it will give the impression that I'm setting myself up as what, some sort of rival Supreme Court. And I've been very reluctant to do that for that reason. I think the body that the Constitution has set up to be responsible for declaring the meaning of the Constitution, interpreting and enforcing it, is the Supreme Court, is the judiciary, with the Supreme Court at its apex. And as a matter of good governance, it's better that that body, which has been given this exclusive power, is the one that is heard on constitutional issues. And that's the reason why I've not been open or vocal on constitution. But I think this one, I feel strongly that I should make some comment. Firstly, the noise that was generated on this, at the time I was extremely surprised because as far as I can see it, and I think the Supreme Court has confirmed it, the matters involved in this thing are open and shut. They're black and white. There can be no dispute about the issues that the gentleman took to the Supreme Court. It is there for anybody who wants to see. In Articles 102, Articles 104 of the Constitution makes it absolutely clear in black and white that the deputy speakers, I'm not speaking of the speaker, I mean the deputy speakers, when they're presiding, have the right to participate in the vote of the Parliament. The whole structure of the Constitution, and indeed, and I believe that would have been part of the reasoning of the court, all the legislatures of the world where the presiding person is a member of the legislature, like our deputy speakers are, like the Speaker of the House of Representatives in the United States, or the President pro tem of the Senate in the United States, or the Speaker of the British Parliament. All of those have the right to speak because they are members of the Assembly. Our Speaker is expressly not a member of the Assembly. That's why he doesn't have the right to vote. In fact, he did really ought not even to participate in the deliberations of the House. He's a referee, making sure that the debate is conducted properly and that the rules of procedure, the orders of the House are complied with. That's his role. But he ought, strictly speaking, not to be part of the proceedings of the House. That is not the case with the deputy speakers. And that matter is transparent on the face of our Constitution. Indeed, even the presiding members of our district assemblies, they have the right to vote. Look at the district assembly law, because they are members of the assembly. And once you are a member of the assembly, you're representing certain constituencies. If you are denied the right to vote, it will mean it is tantamount to denying the right of the people you represent to have a say in the decision of the assembly. That would not be right. So I couldn't understand what all of this furore and controversy that was artificially generated.
Well, yesterday we heard voices of defiance from the NDC minority MPs following the court's verdict. They had accused the court of unjustifiably interfering in the work of Parliament, and therefore they will do as Parliament's standing orders dictate. Well, the President has been speaking to that.
We're being told that the decision of the court amounts to judicial interference in the work of Parliament. I'm not quite sure that the people who are saying this have actually taken the time to read the Constitution of our country. It says so in black and white. The legislative power of Parliament that is vested of the state, which is vested in Parliament, is subject to the provisions of the Constitution. All organs of the Ghanaian state, including me as the head of the executive, we are all subject to the teachings of the Constitution. There's no body in the Ghanaian state that is above the fundamental law of the land. It would lead to the very matter that we have striven so long to avoid, the concentration of power, of unregulated power in our state. We don't want that. We've had that experience before, and we brought about this Constitution in order not to allow that to reoccur. So I'm astonished about how much public energy has been wasted, I would say so with the greatest of respect, been wasted in an area, on an issue where there is so much clarity. And I'm happy that the court, and I'm sure as you're aware, the Supreme Court, when it is declaring the meaning of the Constitution, and it does so unanimously, that is the most emphatic way in which the court can pronounce. And it is, I believe, a decision of 7 of the judges, and a unanimous decision declaring what the constitutional position is.
He says both sides of the House must now move on the back of this verdict.
I think we have an opportunity now to put this matter to rest and continue with the work of our Parliament and the work of the ordering of our state. But as I say, I suspect that it is this peculiar position which we are, with this very hairline majority in the Parliament, that has given rise to all of these disputations and people making claims that are completely beyond the teachings of the Constitution and our understanding. But now that the Supreme Court has pronounced, I think what is required is for the nation, all of us, to get to put that matter behind us and to do our work. To suggest that somehow or other the Parliament is beyond the scrutiny of the Supreme Court when issues of interpretation is to suggest that Parliament is a law in itself. The whole principle of judicial review was developed by the judges, both in America and in England, to be able to check the activities of Parliament. Indeed, in our own country, the first major constitutional case which looked at the work of Parliament was in the case Tufo and the Attorney General, where the act of Parliament, the decision of the Parliament to subject the then Chief Justice, the late Frederick Kwesi Apalu, to a vetting process in Parliament, had been expressly forbidden by the Constitution. And that is the reason why Dr. Makutufo, the late Dr. Makutufo, unfortunately late, took the matter to the Supreme Court. And the Supreme Court made it quite clear that all the activities of all the institutions of our republic that impugn, that violate the Constitution are subject to the powers of the court and to the declarations of the court. Me, I want to repeat it, President, head of the executive, I am subject to the Constitution and to law. I cannot set myself above it. Everybody has his remit, but those remits are subject to the operations of the Constitution. And I'm happy that the Constitution has been so declared in such an emphatic manner by the Supreme Court. Let's support the Supreme Court to continue to do its work. And I'm hoping that I'll not have an occasion again to pronounce on constitutional matters.
I want to now take you to Parliament. Let's bring in my parliamentary correspondent, Parker Wilson, because there's been a major press conference today by the majority side, and they've been detailing their own reaction to this and warning the minority members against the actions that will threaten the democracy of this country. We are also hearing from Joe Sowusu, the first Deputy Speaker of Parliament, who has also been addressing some other issues and also warning the minority guys against misleading the public. I want to bring Parker in now. Parker, we've seen the press conference today by both the majority leader and the deputy majority leader. From what I'm learning, Afanyo Markin, who is a deputy leader, has been warning the minority guys against actions that may jeopardize the democracy of this country. It's in reference to the threats we had yesterday that some of them were insisting, yes, they've heard the Supreme Court, but they will do as the Parliament's standing orders dictate and not what the Supreme Court has said.
Evans, the press conference by the majority is in direct response to the one held by the minority yesterday. Now, according to the majority, they have to take their time and digest the issue before they address the media, and particularly with some of the misleading reports coming from the minority. And so when the deputy majority leader addressed the media today, he made the point that in the past, when they were in the minority, they went to court, they were dismissed by the court, they did not bastardize the judges. They accepted the ruling and moved on. So they want the NDC as well to accept this ruling and move on and stop this issue about trying to, in their own words, destroying every institution of democracy.
Wasn't it their own party member who went to court? Or to them, immediately they go to court, they must win at all costs? That is not fair. And we are drawing their attention to the fact that if they continue to break down the institutions of democracy, one day they will come back to cross the bridge and there will be no bridge to cross back home. The NDC is destroying everything needed to sustain good governance. And that is not how to operate a democracy. Extremist attacks cannot be the way to go. Argue forcefully, when you lose, graciously accept it. And that is what we did when we were in minority. We didn't go out to attack the Supreme Court when we lost in the Kojoga Adra case. In fact, Ghanaian Times reported front page, Afenyo Markin dismissed. Banner headline, Afenyo Markin dismissed. And if you, the 16th of July, that was a banner. Check it, 2015. The whole minority was subjected to ridicule. And the NDC, was happy parading people from the public service to contest party positions, because the Supreme Court says that those category of public servants have not been listed or that they have not been prohibited under Article 94 3B. So, ladies and gentlemen, it is incumbent upon us to respect the decisions of our court. if we are not ready to respect their decisions, then we shouldn't run to them. But once we run to them and they deliver their decision, we should take it as a bitter pill or a sweet chocolate. If it's bitter, take it. Tomorrow, that decision could be an authority for your own cause.
And Parker, it appears that the majority leader has taken some issue with the general secretary of the NDC, John Session Ketia. What is he alleging that John Session Ketia has done?
In fact, Osei Sabonso is not happy with the NDC General Secretary. A few weeks gone by, it was reported that Mr. Johnson Katia had made comments suggesting that if Joseph Osei attempts to vote during the consideration of the e-levy, members of the House, particularly the minority, should use every means, even if it includes attacking him. And so these were the comments that Mr. felt as a general secretary. You don't have to do that. So he criticized him today and also indicated that the ruling of the Supreme Court is not an endorsement of the approval of the e-levy, arguing the e-levy even came before this whole controversy. I mean, the budget was approved even before the e-levy became a matter of controversy in the House.
And for the avoidance of doubt, they say to us that in that regard, and don't forget that some people have gone out there to say, and I should say the General Secretary of the NDC has gone out there to say that in his considered opinion, the deputy speakers are not entitled to any voting. That if a deputy speaker wants to vote and it requires slapping the cheeks of the deputy speaker to straighten his head, that slap should be administered to the deputy speaker. I thought that was a very unfortunate statement that comes from the General Secretary of a political party. Well, you may say that this is my considered opinion, and I don't think that the deputy speakers are entitled to voting. And you are entitled to that opinion. But to go forward to say that if the person attempts to do that, go and be physical on him. Some of us think that it's a very unfortunate statement to have come from such a leading character in the NDC as the General Secretary. Now the Supreme Court has ruled that the deputy speakers can vote and indeed are entitled to the right to vote.
And form part of quorum.
And indeed form part of quorum. To take a decision. The correct number to take a decision. That is what the Supreme Court is saying. So should anybody then say that because he got it wrong, he should also be attacked and be slapped? I think if anybody said that, it would be most unfortunate.
And Parker, very finally, what is this accusation we're also hearing now from the first Deputy Speaker, Joseph Owusu, alleging that the minority members may be misleading the public?
Evans, you recall that when the minority leader, Haruna Idrisu, addressed the press, and of course some reactions from the minority caucus, they had made the point that the taking out of Order 109.3, which means that the Deputy Speaker does not have any votes, means that the Supreme Court has taken away the powers of Parliament. And according to Joseph Owusu, that is very misleading. And that what the court sought to do was to urge Parliament to work within the tandem of our Constitution.
Parker, thank you very much. And to some other issue, though, that also came up on the floor today, I understand that the House was somehow forced to sort of abruptly end business today. What happened there?
Evans, we've consistently talked about how members of the House have deserted the chamber. Yesterday we spoke about it, and today it happened again. That at the time or at the start of proceedings, there were about 7 NPP MP and almost about 18 NDC MP. So the Member of Parliament for Tamale Central, Murtala Mohammed, raised the concern, that is Order 48, indicating that Parliament does not have the needed or the required number to transact business. At the time, the Fisheries Minister had been programmed to answer some questions. So, per the standing orders again, if you read Order 48.3, what it states is that when a member raised the issue of quorum, the Speaker would have to give about 10 minutes interval. So, Joseph said we should then apply that rule. That, well, you've raised a concern, let me give the MPs about 10 minutes and order that the bell be rung. So, the bell indeed was rung. They still were going through with their own proceedings until about 60 minutes when Muntakamugara raised the objection that a matter of quorum was raised on the floor and it appears the Speaker wants to ignore. So he wants to draw the Speaker's attention to the matter. I must say that the Deputy Majority Leader, Alexander Fenyomakin, sought to arrest the motion, arguing that some members had gone for committee meetings, others were now coming into the chamber. So he was pleading to the Speaker that a statement that was being delivered by the Member of Parliament for Efija Kwabri North should be allowed to do so, and members should contribute to the statement. But when the Speaker checked, the time had already gone past 10 minutes, and again, the counting had been done. So the results indicated that indeed they did not have quorum. And Evans, I must say that at the time they did the head count, it was only 41 MPs in the chamber, which fell short of the quorum number. And so the Speaker was then forced to adjourn proceedings. And that is what happened today. And I must say that Murtala Mohammed has served notice that going forward, he would raise the matter of quorum until they get all the needed numbers to transact business.
Epaka, thank you very much. Thankfully, we can speak to Alexander Fenyomakin. He is a Deputy Majority Leader. Mr. Markey, I'm grateful that you could join me here on Top Story.
The pleasure is mine, Evans, and thank you for having me. Good evening to your cherished listeners.
We heard today from the President. His central point was that on the back of the Supreme Court ruling, Parliament should move on and expects both sides to now proceed with the proper business of the House. Taking a cue from the President on the back of the judgment, are we going to now see any proper movement on that very controversial matter of the e-levy?
Well, let's segregate them. E-levy is on its own. The issue of voting by the Deputy Speaker or the Deputy Speaker's voting in a particular proceeding is also another matter. What is settled now is that Deputy Speakers, when presiding, or any other member presiding, can vote, simplicity, and they form part of the quorum. So that has been decided by the Supreme Court. We cannot use physicals, we cannot use any other means to frustrate parliamentary business. As it stands now, that is the position, and I believe that all of us would have to accept it.
I mean, thankfully, your colleague and friend, leader on the other side, Haruna Drisu, is just joining me now. Mr. Drisu, I'm grateful that you could join me, sir.
Yeah, man. How are you doing?
I am fantastic. So, you just said your colleague, Afanyo Markin, and the press conference also warned that the position that the minority have taken on this matter may actually be threatening the democracy, and that you may be destroying the very foundations that this country has been founded by the assertions of resistance, etc., that we've heard. Your reaction to that?
He equally must be concerned about the implications of the Supreme Court ruling on the future of parliamentary democratic practice, which ruling we disagree with. We may be obliged to respect it, consistent with Article 11 of the Constitution, what is popularly referred to as judge-made law, but we have every right to disagree with the ruling of the Supreme Court, more especially when it states that a 30-year rule, which has worked for us, under Standing Order 109, they have said that it's unconstitutional and must be struck out. I've listened to him, I've listened to President Nana Addo Dankwa, and they have oversimplified the matter. Nowhere has a minority indicated or stated that first or second deputy speaker cannot vote. They are eligible to vote as elected members of parliament. The contention has been whether whilst presiding they can exercise a vote when Article 102 provides that the speaker shall not have a custom nor original vote. Now, the Constitution clothes the Supreme Court with the power of interpretation. No one can take that away from them, but they are to interpret the Constitution in accordance with the Constitution. Just like the President said, no one is above the Constitution, including the judiciary. And the same Constitution gave Parliament the power in Article 110 that Parliament shall regulate its own procedure by way of standing orders. Therefore, Parliament regulated its own procedure with Article 109 of our standing orders. The Supreme Court disagrees with us. That is their position. We will respect it, but we disagree. So it is not about the President saying that some presiding members can vote. Yes, they can vote because we provided that they can vote. But we are the same lawmaking entity which provided that when you are presiding, you are not to exercise a vote. I'm a genius student of interpretation, but marginal notes guides interpretation. Article 102, open your constitution. The marginal note is on quorum. And Article 104, the marginal note is on voting. They are not the same. They are distinct and separate, but related. Now, so take it. Assuming Parliament, all the 275 MPs are present and available. Can Parliament commence without a presiding person? Can you therefore commence business because you have a quorum of 275 MPs? I leave that to the judgment of Ghanaians and the public into the future. So to constitute quorum, you necessarily must have a presiding person, which may not be the speaker as spelled out in 102, but a deputy speaker as provided for in our standing orders and in the Constitution. So fundamentally, we have every right. I'm not aware that the minority have taken a position to show any resistance. What we have communicated, we will resist e-levy, because even e-levy itself is double taxation. But because we don't have faith in our court, probably that is why we are not even questioning it. Evans, imagine that you take your salary, 2,500. You have paid income tax on the same salary. You decide to remit 2,000 of that money to your mother. You are asked to pay tax, and you can't call that double taxation.
On the subject
that you have more electronic.
Evans, can I come in?
Yes, Mr. Afenyo Marking, you would come in. Just give me a second there. Mr. Drisu, just on the subject of the judgment, I've heard many minority members suggest that it was judicial interference, unjustifiably so, in parliamentary work when they set aside Standing Order 1093. Do you accept now that it was within the powers and authority of the Supreme Court to do so, to the extent that that particular provision in the Standing Order is inconsistent with the Constitution?
And I say, Evans, the ruling, both the President and my colleague have referred to 4 versus Attorney General 1980. That is authority on the subject. It says that Parliament has a distinct custom of law and practice, and that matters related to it, to paraphrase someone, is closed.
Even if it's inconsistent with the Constitution.
The judiciary ought to have gone the way they have gone. But we will respect it as a country. What we need to do is to work together. But this threat, we'll do this, it won't help anybody. It will not help anybody. This is when you hear minority dictatorship, that erroneous impression. The people of Ghana rightly voted for deeper consultation in order to build consensus, for us to be guided by the collective good of the Ghanaian people, their quality of life, and not the pettiness of NDC, MPP partisanship.
Let me give a word to Afenyo Marking, your colleague. Mr. Marking, they are certainly within their right to critique the judgment as they deem fit, correct?
That's what we've done. So beyond the critique, I'm not aware of any matter.
Okay, let me hear him on that. Let him hear him on that. Let me hear Afenyo Marking on that question, that your right to critique, Mr. Marking.
Well, it's within their right, but if they can proceed with that critique in good faith, what they are doing is to scandalize the court, and they are indeed scandalizing the court. You see, this ruling or judgment is not novel, it's not new, it's not something that is just coming out of nothing. Please, with the greatest respect to my colleagues in the NDC, I refer them to Kojoga Adra versus Ni Lamte, Pa Ni Lamte, and the Attorney General. 2015, I led the charge at the Supreme Court when some people were contesting on NDC party ticket and they were in the public service. And the minority then held a view that Article 94(3)(b) must not be interpreted in isolation, and that all public servants, by parity of reasoning, if you work with Ghana Education Service and somebody is at the Ministry of Education and is being prohibited, you in the public Ghana Education Service, also a public officer, must be prohibited. We took the matter to the Supreme Court. The Supreme Court was clear. Unanimous decision. 15 July 2015, Dr. Ayeni made the argument. I pray that he gives his legal submissions to my respected senior Harun Idrisu to have a look at it. All that they contended at the time was that, look, if the framers of the Constitution had intended to make other people part of those listed under 94(3)(b), they would have said so. The Supreme Court agreed with them that let us treat them separate. Now, what is the argument today? They are saying the Constitution is clear that the Speaker shall neither have an original vote nor a casting vote. To them, by parity of reasoning, this should be extended to any other person who will be presiding in that capacity. The Supreme Court is saying that no, it is different. If the Constitution and its framers had intended to include deputy speakers, and for that matter, other members presiding, the Constitution would have said so. The Supreme Court is only following its earlier precedents in Kojoga Adra. They celebrated Kojoga Adra. Why are they the same reasoning that they supported? Why are they departed? Let me bring you to another case, the Makesebe Yabua case. We had gone to court to challenge ECG, saying that ECG, government was using ECG as its alter ego, and that the whole transaction where car power transaction, GMPC was giving residual guarantee, and Ministry of Finance was also given undertaking to be ultimately responsible, amounted to a transaction that government of Ghana was a party. We went to Supreme Court. In opposition, we lost again by 7-0. What did the court say? The court said, look, to the extent that is the board of directors of ECG that have passed through as a resolution, they have agreed to the transaction, have signed off. We could not say that because there was a residual guarantee, government of Ghana was a party. We accepted it. That is the interpretation. That is how the court operates. So for him to say that it's the Constitution, the Supreme Court was supporting e-levy, Harun Idrisu knows that political statement he made was incorrect, unacceptable, was scandalous, and I beg to submit that if we don't support the institutions of state as politicians, we would end up compromising our journey towards good governance, and we would give room for some adventurers to think that we are not serious in our politics. In any event, the gentleman who went to Supreme Court to challenge raised this matter. And they know they are party member. Can they deny him that he's not a member of the NDC? He's a non-NDC member. It is not as though some MPP person went to Supreme Court to, invite them to rule that the deputy speaker or a deputy speaker presiding should be allowed to vote and all that. Their own party member went to court.
Yeah, I mean, Ahana Drisu just indicated that he's not aware that he is. But I want to say thank you very much, gentlemen, for your time here on Top Story. That's Alexa Nathaniel Marking, who is the Deputy Majority Leader, and Haruna Drisu, who is the Majority Leader. I'm sure you've heard both sides of this. You've heard the lawyers also speak to this. You've heard the Supreme Court and the President. You must have a view on this. It's about you. I want to hear from you here on Newsnight on Joy 99.7 FM. Still ahead here on the program, nearly 2 months